Great. Thank you so much, Mary Kay. It's really great to be with you all today. We're here talking about how we can expunge eviction records for survivors. And we have brought a team of experts from the Indiana Coalition Against Domestic Violence, and they're going to join us today and tell us all about what they're doing in the state of Indiana. And hopefully it will apply and give you inspiration and ideas to implement similar projects in your state. So I'm Debbie Fox, or D Fox, and I work at the National Network to End Domestic Violence. We can go to the next slide, please. I am part of a team of really amazing technical assistants, experts, and partners at the federal government that are part of the Domestic Violence and Housing Technical Assistance Consortium. Since we're just here for an hour and have limited time and a lot of content, I'm not going to go through all of our various partners, but I do encourage you to look at the Safe Housing Partnerships website, safehousingpartnerships.org. We have a ton of resources there at the intersection of DV and housing and homelessness, and we go into a lot more depth about the various TA providers and the supports that we provide there. And then there is a place also to request technical assistance and more information from the DV Housing Technical Assistance Consortium. Just one quick piece around the work that we're doing. Next slide, please. A lot of the work that we do is we're bringing folks together to work and address the issues that survivors are facing as it relates to housing. He does a point in time count every September that many programs, but probably on this call, participate in. And the number one issue that survivors are facing and requesting services for are shelter and housing. We're looking at many ways, in addition to providing shelter and housing supports, we're looking at other innovative ways to support survivors. And one way of doing that is keeping people housed or doing eviction prevention, or in this case, that we'll cover in the webinar today, eviction, to make sure survivors have more options when they're looking for housing and seeking housing in their community. Next slide, please. So basically our work and a lot of the work that I do with the Indiana Coalition and many other state and territorial domestic violence coalitions across the country is really bringing our learning communities together, strengthening our network, and really providing a comprehensive and national response to addressing domestic violence, and particularly around housing and addressing the systemic barriers that survivors face. So that's it for me. I'm going to be in the chat box and I'll be there answering questions, but I'm going to pass it over to our awesome presenters at the Indiana Coalition Against Domestic Violence. They can introduce themselves and tell you all about the great work that they are doing. And I'll turn it over now to Indiana, to Carrie. Thank you.
All right. Thank you. Oh, there we go. Did I just, oops. And who's in charge here? Okay, hi, good morning. My name is Carrie Hyatt Bennett. My title is Chief Legal Counsel at the Indiana Coalition Against Domestic Violence. I've been here for 20 years. I've been an attorney for 35-ish. I'm also an adjunct professor of law at the Indiana University Robert H. McKinney School of Law, and I teach a class appropriately titled Domestic Violence Law, Public Policy, and Process. So thanks for being here. We're really excited about some of the work that we're doing here in Indiana. So I'm going to turn it over for introductions to my colleague, Erica Young.
Hi, I'm Erica Young. I'm the Housing Program Manager here at the Indiana Coalition Against Domestic Violence. I work closely with the legal team here on the eviction expungement, but primarily I work on expanding housing options for survivors throughout the state of Indiana and working with member programs, providing training and technical assistance. And I am going to turn it over to Nupur.
Hi everyone, my name is Nupur Chandna and I'm an attorney here at ICADV. I work both with the legal team as well as with the economic justice team. And without taking up more time, we're going to get rolling and I'm going to pass it on to Carrie to start.
Okay, thank you guys. We have a great team here that works in housing. More acronyms than I've ever seen in my life. I didn't think there could be more legal acronyms, but housing is a world in of itself. Thanks, everybody. If you work in this world, and we all do, that domestic violence and housing are completely intertwined, right? What we know about survivors is one of their primary concerns is affordable, safe housing. And housing insecurity is one of the many reasons why survivors stay in domestic violence relationships. They will choose to be unsafely housed over being homeless. Housing options are critical for survivors. We all know that. In Indiana, over 80% of homeless mothers with children previously have experienced domestic violence. Those statistics are similar on a nationwide basis, but statistics say 65% of domestic violence survivors are looking or have had trouble finding housing, qualifying for housing over people that are not coming from abusive situations. And 38% of all domestic violence survivors become homeless or without housing at some point in time during their lives. So it's a real issue. And as we started to pivot into legal work, and historically my legal work at the coalition and before has always been responsive historically, it's been responsive in domestic violence cases. How do you respond when domestic violence happens? A decade or two ago, when we started making that pivot towards prevention, we started thinking as a legal team, how do we use our legal powers for good to prevent domestic violence from happening in the first place, to prevent further victimization? And when we started focusing on housing, we came up with basically a legal approach for survivors. Not only do we advocate for housing and for secure housing on behalf of survivors, we advocate for survivors when they're being forced by their alleged perpetrator. We advocate for housing in eviction response. We will represent that person and see if we can get on the other side of an eviction action, hopefully being able to get it dismissed. And in Indiana, now we have the opportunity to get it expunged if it is dismissed. And eviction sealing, which is basically eviction sealing, eviction expungement, which means that if you can seal that record, then it is not publicly accessible on our state court database. So we started thinking about how we can use the law to help survivors keep their housing, obtain affordable housing, avoid evictions, negotiate move-out agreements, how we can use that so we can help survivors stay in some secure and affordable housing. That's our goal from a legal perspective, and we've done that in a couple of different ways, and we're going to talk about that in just a second. Indiana has, to their credit, Indiana has recognized that we have a housing crisis in this state, as we do in this country. But I think it's safe to say, and Erica can maybe nod her head, but I think it's safe to say that our housing crisis in Indiana is as bad, if not worse, than the national average. We have a tremendous eviction problem in central Indiana. We have a candidly very landlord-friendly eviction statute. It is always challenging to deal with housing issues when for anyone in general, but much less when we're talking about survivors. And a lot of survivors don't have the knowledge base, which makes complete sense because a lot of people don't have the knowledge base to know that a certain threatened eviction is an illegal eviction, and they can do that and they can't do that. And even notifying survivors and the public in general about their housing rights has been really critical. It's really part of what we try to do. A little bit of background, the Indiana Coalition Against Domestic Violence, as you all probably know and understand, is the umbrella organization over the domestic violence programs in the state of Indiana. I serve as their general counsel. So not only do we help with legal issues that our programs face, but we also run a limited legal services program for survivors in their civil hearings. We also do a lot of direct legal eviction work. We will represent survivors in their housing cases. So that's part of what we do, but we find that our housing work is an increasing percentage of what we do because it really makes a difference for survivors. That being said, Indiana was pretty progressive to recognize that we had an eviction problem after the pandemic. And our courts, to their incredible credit, our Indiana Supreme Court has been very progressive about not only taking a stance about helping people in their eviction hearings, but giving them an opportunity to negotiate out of it, training judges to be compassionate, and training judges to be more empathetic towards survivors. They can't change the law, the Indiana Supreme Court, but they can counsel and coach judges that this is what we are doing by rulemaking We really want people to be able to divert an eviction if they can. We really want to be able to empower people to approve, if you're a judge, a move-out agreement in lieu of an eviction. They can't make landlords do any of that, but they can encourage courts to foster that sort of approach. If the individual wants to have some sort of negotiation with the landlord, if they want to craft a move-out agreement, if they want to make a payment schedule or something like that, what we encourage individuals, including survivors, to do is to make a paper trail of their willingness to work with that landlord and then make that argument in the eviction court, because the judges have been put on notice that this is a priority. A priority is that we don't end up having thousands of people with bad eviction records that will foster homelessness in the future. So getting a lot of credit to our Indiana Supreme Court and our court leadership to teach our trial court judges to be a little empathetic when it comes to eviction cases. So that being said, right after the pandemic, there was a lot of concern about the Scarlet E. I'm sure you've heard that. If you have an eviction on your record, and I can pull it up in Indiana, I can only speak for Indiana, I can pull up mycase.in.gov and I can pull up our court records. If what we were finding is if you're a landlord and you're contemplating renting to somebody, you pull up their name in mycase.in.gov and you find that they've had 2 evictions in the past. The problem with evictions and the detrimental effect of that Scarlet E is the eviction can be filed and then it might be dismissed 2 days later if somebody catches up on their rent, or it might be dismissed in a week if someone catches up on the rent. Filing an eviction is talk about a power move. It is a power issue. It is a coercive response to having somebody, if somebody is behind, if you file an eviction, it'll scare the daylights out of them and they will probably catch up just to avoid being evicted. But the problem here with our court system is once you file that, it doesn't go away. If somebody files an eviction against me, I turn around and pay my rent when I can, and they say, well, don't worry about it, we'll just dismiss it. They'll dismiss the eviction, it'll still be on my case, and it doesn't go away. This statute that was passed right after the pandemic is a tool that allows people, if your eviction is dismissed, if your eviction is overturned on appeal, if your eviction does not result in a judgment, if it just results in a possession, then you can have that eviction sealed. And we're trying to use that information and that new statute to help survivors expunge, get rid of those old evictions so they have a better options for getting secure and affordable housing. So that's what our eviction expungement is. I'll go in a little bit in that in a second, but basically this was written in 2022. It went into effect in July of 2022. There is no waiting period. If you have an eviction that has been dismissed, you can immediately file the paperwork to have it expunged or sealed. They're the same thing. In Indiana, our expungement statutes seal documents. They don't take them away completely. Very often law enforcement can still access criminal expungements, but they do seal them for the general public. That record can't be used against them. Sealing someone's eviction record in a couple of different cases or in any of their cases allows them to obtain better housing. So it came into effect in 2022. There's no waiting period. You can feasibly ask for the eviction to be expunged when you're at the hearing that results in its being dismissed. This morning, I had a call with one of our domestic violence program. We have confidential Zoom calls with individual survivors, and I had a confidential Zoom call with an individual survivor and her program advocate, and she said, I've got 2 evictions. I don't know what to do because they're literally keeping me from getting housing. So it is as simple as pulling it up to find out what the status of that eviction case is. One of her eviction cases had been dismissed over a year ago. There was no judgment entered, so there was no money anymore. Possession was already resolved and it was basically dismissed, but it was sitting there on my case. I was able to tell her that's expungible. All we got to do is file the paperwork. So reviewing these cases for individual survivors to let them know what they can do next, how we can help them get rid of that record has been, we think, super helpful to survivors and a really good service for our domestic violence programs around the state of Indiana. What we're also finding out is because our Indiana Supreme Court has had such tremendous leadership among the trial courts, what we're finding out is courts are approachable. Judges are approachable about this issue. Landlords, not always, but judges are very approachable. So if you approach a judge and say, we'd really like to work this out, because obviously, judge, an eviction on his or her record is going to be really detrimental to their ability to rent something else in the future. So what we'd like to do is work out a payment plan of some kind, maybe get the eviction dismissed once everything is paid, and then maybe we can work towards getting it expunged. So we find that the courts are very approachable about options. The landlords don't have to agree to them, but it also puts the landlord in a position where if the courts believe this is in the best interest of justice, it does have a tendency to put the landlord on their back heels. I'm going to pause and breathe because I saw some things popping up in the chat. So if somebody wants to interrupt me and ask me anything.
There's just one question I want to highlight. Somebody asked that, do you need the plaintiff's approval for the record sealing or expungement? And no, you don't need the plaintiff's approval, especially if it has been dismissed or because it was overturned. So you don't need to get the plaintiff's approval for automatic sealing provisions.
The plaintiff meaning the landlord, I'm assuming.
Yeah,
Yes.
I'm assuming that. And I think the request at the beginning was that if you could put the questions in question and answer, they're getting lost in chat. We cannot keep up with them. And if we do not get to the questions during the meeting, we'll get back to you later.
You betcha. And or Erica, if you could put my email in the chat, I'm sure that, or somewhere, although I know it's all over the slides, but we're going to get to all of this. So here's what the Indiana law allows. And if you want to rip off this law and see if you can get it passed in your state, power to you. We could have, I know we would have survivors testify on behalf of this. It wouldn't be the first. I ripped off a couple of laws from North Carolina 10 years ago. And anyway, so feel free to ask me for our statute and I will certainly send it to you. So what is required is the petitioner's full name, their date of birth, their current address, the eviction cause number, a description of why the petitioner is entitled to relief, the eviction was dismissed. In Indiana, I should lead with eviction cases in Indiana are bifurcated legal situations, which means the first hearing is a possession hearing. And then it's usually followed with a damages hearing of some sort. Even if this goes to a possession hearing and the plaintiff or the landlord is granted possession of the residence back, that's still expungible. The only time that you can't expunge it is if it's reduced to a judgment. When I'm screening these cases and if I see one has been reduced to a judgment, then we got a whole different ballgame and our approach is going to change. But it is automatically expungible and it's a mandatory grant if there is no judgment that has resulted, if the possession issue has been resolved, and then we usually put a paragraph in there about why this is such an important issue for this particular survivor. So far, we have been incredibly successful at being able to do this, and it's usually done relatively quickly. Nupur, you filed a bunch of these, so what sort of turnaround time are you seeing for these?
If it's a straight case where it was dismissed or overturned, it's fairly fast. Sometimes somebody even put in question, when would it not be, like when would the courts reject it? The court would reject it if it doesn't meet the criteria, the 3 steps, the 4 steps that they've listed out in the statute. And because sometimes, I know Kerry will get into this later on, but there are certain gray areas that she will talk about. If the case falls in that gray area, it's not automatically sealable. And that's when they will not automatically do it. Like if the eviction was done, but there's a damages hearing, and there are the certain technicalities that the court can deny it. And somebody asked if we could give the statute as the provisions are listed here. And I'm trying to get to the questions and answers as fast as I can. I know I'm not very
We'll
fast,
get
but
there.
I will do what I can.
We'll get there. And you can always email us. When we have the PDF of this PowerPoint, I can send Deb the statute so she can send all of that out if you want. And sometimes we make it as easy as possible for the judge. And I'm going to say, as an attorney, this is where having an attorney weigh in on this is a big deal. Because first of all, survivors, individuals don't largely know their housing rights. They don't know that a lockout is an illegal eviction in the state of Indiana. They don't know if something is posted on their door, if it's true, or if they can do it legally, or if they can't do it legally. So there's a lot of power imbalances between landlords and individuals, and especially between landlords and survivors, who the fear of facing being unhoused is about as bad as it gets. So having an attorney, or having either a pro bono or a modest means or some attorney who does this all the time, that's a game changer. Because when they start working with an attorney, they're going to meet you toe to toe, and that power imbalance is gone almost immediately. And that's a good thing. After the petition is filed, the court may grant the petition without a hearing. Usually it does if you meet the requirements. Courts will very often do as little as they need to do, right? So if it's a mandatory grant, 9 times out of 10, they're going to grant that. Sometimes they might set it for hearing if they want a little bit more information. If the landlord is objecting, they might set it for hearing. But what I find is, if you meet the requirements of the statute and you make a compelling argument for why this is a big deal for this person, it's keeping them from getting affordable housing, then usually the court will grant it if you meet all of the criteria. The burden of proof, the petitioner bears the burden of proof, obviously, the person asking for the expungement. And another good thing about this statute is, if you mess it up, you can always refile it. Our criminal expungement statute in the state of Indiana is pretty much a one-shot deal, although I've seen a little flexibility on that. If I help somebody file a criminal expungement case and there's a flaw in it, according to the statute, you got one shot at it. In real life practice, I don't know if that's actually all that true, but in this particular statute, if something goes wrong or if something is not filed correctly, you can always refile it. And that's been important for survivors as well. So what does the petition do? The petition, if it's granted, takes the eviction case off of my case. It takes it off of public record. It keeps it from being checked on by other people. So it's not something that can be used against them. Again, the ones that you can expunge are cases of eviction that have not resulted in a judgment, have been dismissed, overturned, or vacated. So if you have a situation where the landlord is, like I mentioned before, somebody's late for their rent, they file an eviction case, that might be expungible if you can resolve it before it goes to a judgment. And from a practice area, there's a lot of flexibility for lawyers to do this. There's, hey, I'm representing so, obviously with his or her permission, is a survivor, and this is what they're going through right now. So what we really like to do is work this out, craft a move-out agreement. So you get your money, everything is fine, dismiss the eviction, we can get it expunged, and then they have a clean housing record. Do you have a problem with that? It's next to super easy, and it shifts that power imbalance. And I have run into very few attorneys that work for landlords that have said, nope. For the most part, they have been approachable because they just don't want to be that person. It has been more successful for an attorney to do it, unfortunately, than it is for the survivor to do it, because very often they don't know it's a viable option. Some questions that may arise when an eviction order is not made, but a judgment is issued for damages. Some courts will seal the judgment if it's paid off. I have done this as well. So most counsel on the other side have been approachable if I've said, hey, she's got a judgment in this eviction that's really old. She was living with her abuser at the time. The judgment is $5,000 total. What do you think about reducing her judgment to $2,500? We enter a payment plan. You have and then I can file a motion to set aside the judgment. If you don't object, we can set the judgment aside and then she can get it expunged. The idea is you're going to get your money, so why take her housing record down with you? So there's lots of different nuances that you can do. Can you set aside the judgment, even if there is one? They have to agree, obviously, but it's certainly something that you can approach somebody on. But if it goes to judgment, it doesn't qualify under the statute. That's why if it does go to judgment, then we try to take a couple of extra steps and get that judgment set aside. If we can work with Nupur, work with Erica on the economic justice program, maybe we can help them in some capacity pay off that judgment so it can be set aside. Let's see, what else do we have on here? When a case is dismissed after the eviction order, but before the damages hearing, definitely expungible. When a tenant remains in the unit after an eviction order and the eviction order expires. I haven't had that happen, but I think this is correct when it says that might require a motion to vacate, but until I see a judgment against that person, then I'm going to assume that it is expungible. I think it's an argument that can always be made. I think courts in Indiana are largely approachable about this because they do recognize the housing crisis that we have. When a tenant is vacated before the hearing and the order granting possession is not clearly an eviction order or says it is not an eviction order, I've been able to get those expunged as well, because then you can get the entire, and then you can get the entire action dismissed if it didn't result in a judgment. And again, I think judges in Indiana are largely approachable about remedies if you have something sensible that makes sure the landlord gets paid as well. We have great pro se forms. We have a relatively new website put up by our Coalition for Court Access in Indiana, which is our Access to Justice Commission, and it's called indianalegalhelp.org. Anybody can get on there, check it out. If you get on indianalegalhelp.org, check out the eviction sealing forms, and you can literally download what one of these things looks like. Okay, it basically follows the statute. It asks for the information. You can put a narrative in there about why this is such an important remedy for this survivor, and all of that information is on there. In fact, I believe they have a link to a little handbook about how these are done. In very real, this is how we have been doing this at ICADV, but because there's two full-time attorneys and one part-time attorney at ICADV. We run a satellite attorney project where we have a modest means panel of about 50 or 60 attorneys that work for us for a modest means hourly. They represent survivors of domestic violence in critical cases in their civil protective order hearings and some housing issues and things like that. So we rely on our satellite attorneys to do some of this. A lot of this we do in-house when it comes to just negotiating move-out agreements or talking to survivors one-on-one about how they can file these forms pro se. They are relatively pro se friendly. If you want to pull them up, you can check it out. And we've also started implementing monthly evictions clinics, which is cool. We have one tomorrow, as a matter of fact. And we send out a registration link to all of our domestic violence programs. They send it out to the survivors that they're working with. They hang flyers. They do all kinds of things. And it has a registration link. If the individual gets on that registration link and registers for it, asks for, confidentially, of course, it asks for name, cause number of the eviction they're interested in expunging, a little bit of information. When they all drop into the clinic tomorrow, and there's probably 15 of them scheduled for tomorrow, which is pretty good because it's monthly. Those 15 people, we will, with the help of Erica, we will move into chat rooms individually with an attorney. So I will sit down and talk to one of the survivors pull up their eviction, talk to them about whether expungement is a viable option, guide them towards the form. Sometimes we help them fill them out. Obviously, sometimes there are barriers like a language barrier, if a literacy barrier, etc. If we can, we will do it for them. If there are special nuances in the case, then we'll maybe accept it for full representation, depending on what's going on. But our pro se clinics have been really helpful because it's a chance for people to meet with an attorney one-on-one about that specific eviction and whether it's expungible, and if it's not, then why it's not. And every single one of the survivors that works with us in these is also working with a victim advocate from a domestic violence program. If I'm working with Sandra, who's working with her advocate named Jane, then I'm going to say, hey, Jane, this is what I would suggest that we do here. Maybe reach out to the Economic Justice Fund and see if there's some short-term financial assistance to help this person get out of this lease so we can get it expunged. Try to holistically look at that situation. And so that's been really helpful too. So these are pro se legal clinics that we have on a monthly basis. And the topic has been largely eviction expungements on those days. If you want more information of that, for that, just shoot us an email and we'll get right back to you. This is the particular part of the Indiana code that talks about what is required, and it's pretty straightforward. It's basically the expungement part of this statute, brand new in 2022. So this basically says if it has been dismissed, if it has been overturned on appeal, if the eviction has been vacated, or even if the eviction has resulted in a possession hearing, those are all expungible. The only time they are not expungible is if it is reduced to a judgment. If it's reduced to a judgment, it's not expungible, but it's also something that you can approach from a how do we get rid of this judgment? How do we get this judgment set aside so we can work towards expunging it down the road? Again, this is the statute that talks about about the requirements for the petition, Indiana Code 323111-4. If you pull up those petitions on indianalegalhelp.org, you will find that the petitions follow this almost exactly. All you have to do is fill in the blanks. It's a PDF fillable form, and it's very helpful. I don't know about everybody, but we have e-filing in the state of Indiana, which is great, but we also allow people, and will always allow people, because it's an access to justice issue, we will always allow people to file paper. Because of course, mandating e-file assumes everyone has a computer, and we don't do that. So we encourage e-filing, we love e-filing, but at the same time, we will always allow people to file on paper. Okay, this is the code section that talks about, again, it talks about the burden of proof that the person that is asking for the eviction expungement has. Again, this is where the narrative really comes in as very helpful for the judge to see why they want that sealed. And if they make a compelling argument as to why an eviction on their record really does detrimentally affect their ability to seek housing in the future, it's a pretty compelling argument for most judges. Some of the quirks, if the case is brought under an ejectment statute, that's an Indiana-specific quirk. There are some practitioners out there that don't file evictions, they file ejectments, but they're basically ruled by the same statute. One of the cases that I have now refers to the second point, where if you've got somebody that's living with their abuser or former perpetrator, and there's a judgment in both of their names, how do you bifurcate that and make the argument to not only opposing counsel, but make the argument to the court that you're asking for this judgment to be bifurcated so my client can be held responsible for this amount of money. I've had this morning, again, I was working with a survivor who has not paid anything towards her eviction judgment, not because she can't, but because her former abuser, who is also on the judgment, said, ignore it, don't pay anything on it, I'll file for bankruptcy and then you'll have the entire debt, which legally is not true in the state of Indiana, which is if you do what I do, we spend a large amount of our time arguing with what survivors have heard that is just not correct. It was important that she know that they can bifurcate that judgment if we effectively make that argument that it's allowable under Indiana law, and let's give it a shot. The worst thing that could happen is the judge denies it, and the judge would probably have to have a compelling reason for denying it. So just some little quirks, but nothing that we haven't been able to think outside the box on and come up with some interesting ways of pleading around those issues. This is an interesting issue. Indiana has a records privacy court rule, and that's Rule 6. And you can make the argument that you can ask it for the court to seal, not seal as in get rid of, but you can ask the court to make some records in cases where there is presenting a significant, and I've done this a handful of times for survivors. It doesn't get rid of their eviction. It doesn't get rid of the judgment. What it does do is it seals it so it keeps the offending party from finding out any information about them. We've done this in name changes before. We've done this in other gender marker changes. We have done that, but it allows you to, under a separate rule, get in there and ask the court to seal the record for the person's safety. But you have to make a compelling argument that there's a substantial prejudicial effect if this is publicly viewable and that there is a risk of significant harm. Indiana, again, because we have started recognizing, we have been recognizing the crisis in this state. If you get on our mycase.in.gov, it says at the top of it, if this is an eviction case and you need help, click here. So you can click there and it takes you to this screen that bifurcates it into, do you need rental assistance? If you need rental assistance, go here. Are you requesting a mediation session with your landlord to see if you can work this out? If you're requesting a mediation session facilitated by the state court administration, click here. And then the other one is, are you looking for forms related to your eviction? Click here. So it's actually quite progressive. And the statute says that mediation options must be allowable to the person, but they are not mandatory for the landlord. So your hands are tied to a certain extent, because as a petitioner or an attorney representing a petitioner, you can ask for a mediated agreement, but the landlord does not have to agree to it. What I find, though, as counsel is they have a little tougher time pushing back against counsel than they do the individual person. Not to mention, so many of our survivors don't know these are viable options for them anyway. So we really want to get there, and we want to encourage them to understand and pursue some of these remedies that they do have under Indiana law, because there are not enough of them as it is. So we do have a pre-eviction diversion program where you can ask for some sort of mediated settlement with your landlord. Again, it's not mandatory for the landlord to do that. Helping survivors navigate eviction. We also have implemented a legal housing hotline here at ICADV, which has been really interesting. We weren't sure how this was going to go over, but it's actually been very helpful. It allows survivors to call. It's not a crisis line in the sense that there's not somebody on the other side of it 24/7. It is a legal housing hotline, and it allows individuals to leave confidentially, leave questions, leave information, leave a callback number. They can do it by text. Most people have our email contact anyway, but it allows them to get a little housing triage if they're a survivor, and we can get back with them about maybe connecting them with a domestic violence program if they're not working for one, pointing them towards the right forms that are available online, just giving them information about the law. I'll give you another example. I had a survivor call me earlier this week and say, okay, this is a domestic violence situation, but it's not in crisis now in that regard because her abuser's in jail. Her abuser's in jail. She's glad. She's happy. Everything is fine. What she's finding here is the landlord has taken this opportunity to keep coming into her apartment unannounced. So what are my rights to keep this landlord from just coming into my apartment and saying there's an emergency when there is not an emergency? It's now that he's not living here, I got a landlord that's coming into my apartment at all hours unannounced, and it's scaring the daylights out of me. So being able to not only advise her what Indiana law says about that, but even getting one of my colleagues who is an amazing attorney in the housing area to spend 3.5 minutes of pro bono time to give this landlord a call can be pretty compelling how to balance that line, because we certainly don't want her to be evicted, but we do want to make sure that the landlord knows that she knows her housing rights. The legal housing hotline is a perfect opportunity for them to voice those concerns, and then we can triage them when we either call them back or get back with them. So that's been pretty successful, and that was more or less free to set up. Again, our eviction expungement clinics are, at this point in time, they're monthly. We have helped 44 survivors so far. We have another clinic tomorrow, and I know we have about 15 people scheduled for tomorrow. That's been proven very helpful too. And that's just a relatively small amount of work product time, but it's a really good investment of that time. And access to economic justice funds. I'm going to tag Nupur on this one, because this is where we make a good team, in the sense that if we're working with somebody that's crafting a move out agreement to avoid an eviction being filed, then I'm going to try to connect them to see if we have any economic justice funds, and we're going to think outside the box how we can meet that legal obligation, that monetary obligation, so it does not result in a legal filing. Nupur, you want to say something about that?
Yeah, and I'm also going to tag Erica on this, because this is actually really how the team comes together, because Erica is generally their first point of contact when they need something like this, and she will circle back to the economic justice team at ICADV, which is an entire team of people dedicated towards this. It is the source of funds for this. I want to highlight is it's a mix of both public and private funds. We try, once we get these requests, we meet weekly, we go over the applications, and if there is somebody we can help a survivor prevent an eviction go on record, we would try to use those funds. And as you can see, just in the last quarter, the numbers that we have put out there, we have spent over $10,000 just paying eviction debt to prevent people have an eviction on record, about $69,000 just in housing cost, rent and security deposit alone. We're not talking utility or anything else. But I'm going to go back to Erica to see, I'm sure she has more to tell you on how this runs.
Yeah, no, that's great, Nupur. I think you've pretty much touched on everything there, but yeah, these funds have been so helpful. Nupur said it is a mix of private and public funding, so the more flexibility, the better with these funds to help survivors and meet the needs that they currently have for housing. We do get a lot of cases that start with, I am being evicted or I'm facing eviction, what can I do? And that starts with us getting them into contact with a member program, linking them to services, but also getting their rent current, and then focusing on getting those records sealed or getting the next steps in process there. Yeah, that's how Poor's right, that's how we all come full circle and back together. So we've been so grateful for all of those funds that we've been able to use to help survivors with eviction and to prevent eviction. I do want to highlight something in the chat, Carrie, that I think that you already answered, but it was around how are we advertising or getting the word out to the public on expungement or the work that we're doing. And that's a mixture of different outlets of media, social media, the flyers that are created by our communications team go out to partners.
Right.
And then I know Carrie works with a whole other network of attorneys that also have that information.
Yeah, we send it out to our satellite attorneys. There's probably 50 of them around the state of Indiana. and they can send it out to Indiana. Because we have been pretty progressive about this, a lot of our stakeholder partners, Indiana Legal Services, Neighborhood Christian Legal Clinic, these are other broader legal services. Our legal services are pretty focused on domestic violence survivors. So there are eviction expungements. In fact, if you get on indianalegalhelp.org, there's a link to all of the eviction expungement clinics on there. So there are plenty of clinics by other legal service providers that have a broader base than we do. When we advertise or when we promote our eviction sealing or our eviction expungement pro se clinics, we really do want to work with survivors because we know that we do have a limited capacity. We're not quite as extensive. We're not primarily a legal services organization. We're a coalition against domestic violence. So our focus is on capturing domestic violence survivors that need those expungements for their safe and affordable housing. So we don't advertise for the general public as much as we do try to focus on individual survivors. All right, was there another? What is the process to have a guard? I just lost it. Erica?
Yeah, we'll go ahead and go to the Q&A section. That wraps up the presentation. We do have a couple outstanding questions in the Q&A box, Carrie. Specifically, in Rhode Island, judges are not typically approachable or open to training as well as attorneys. Do you have any recommendations for these cases?
Yeah, that's as someone who's been trying for 25 years to train judges and consistently, that is a challenge. I tell you, we got so much leadership from our Indiana Supreme Court, but for our Indiana Supreme Court, I'm not too sure we would have grasped this as a housing eviction crisis that it is. But we have a very progressive Indiana Supreme Court, so I'm gonna lay a lot of it on them. The Chief Justice talked about it in her annual address. We've had lots of press on this. And COVID money was able to be able to go to housing issues, which our Indiana Bar Foundation used to fund some eviction expungement work as well. So this all came from a post-COVID concern about affordable and safe housing, and it blossomed from there. So that money, obviously, because of all COVID money, it's probably not going to last forever. But a lot of the projects that we've taken up as part of this are going to be self-sustaining anyway. So they're not completely like the eviction, the legal housing hotline. That's extra time on our part. But as far as tapping into additional resources, it's a relatively cheap ask. So training judges is always a challenge. And I would, if you have a state court administration, which we work really well with, sometimes we do trainings with them. So I would pitch it to your state court administration. If you have colleagues or partners that are working with the Supreme Court, they need to capture how critical housing is for individuals and survivors. Are there any? I can't see.
There's more questions.
Yeah, there's a few more questions. Since we have a little time, I'll go ahead. There was a question around if we have any data on people trying to take advantage of the program who are not VAWA survivors, which I don't believe that we have data on that. We can share information on in.gov or the state of Indiana that would provide some look into access to those services for all.
And when you think, but the first thing I think of is federally subsidized housing, right? Because of the relief, available for housing survivors under the Violence Against Women's Act. Then you're talking about petitions to transfer, and you're talking about VAWA notice of rights and all of that. To me, that's very different than the eviction expungement. We don't require eviction expungement can be private housing. It can be public housing. It can be all of the above. We don't require that to be VAWA connected in any way. There's no notice of victims' rights. There's none of that stuff. If you're a survivor and you have a housing eviction that you want to see if you can get expunged, we're going to see if we can do that for you. So it's unrelated to VAWA. Indiana law in that same vein, AWA has tenancy relief for survivors that are in HUD housing, and public subsidized housing, but Indiana also has a separate law that provides some resources for domestic violence survivors who need to have their locks changed, have their lease broken, or other things like that. And that's private housing. That's not VAWA, federally subsidized housing. If you want more information about, that's a statute we've had in effect since 2007. And that's the one I ripped off from North Carolina when we wrote it. But that's been a really important thing too. So happy to share that with you. What was the other one? Process to have a guardian ad litem assigned to someone due to mental incapacity. Would the housing court case be expungible? Wow, I see those as two completely separate issues. The process to have a guardian ad litem assigned to someone due to mental incapacity. I think that would be under our Adult Protective Services statute, which is Indiana Code 12. The housing case, Ken, if you want to follow up with me, or if you want to unmute, or I know we're running out of time, but if you want to follow up with me, shoot me an email, because I'm not exactly sure where we're going with that one. To me, I see the housing and the adult guardianship as two separate issues. Okay. Anybody?
I think that takes care of all of the questions in the Q&A for now. We can pass it back to Dee to make sure there's no other information on Safe Housing Partnership that needs to be covered before we wrap up.
Thank you so much, Erica, and thank you all from the Indiana Coalition. This has really been a very informative webinar. As we can see from the chat, people have a lot of gratitude for all the information that you've shared, and there's been a lot of great questions and a lot of dialogue, both in the chat box and in the Q&A. I just want to thank you all for being here, and please reach out to Safe Housing Partnerships or reach out to the Indiana Coalition. I think the emails were in the chat box, but we definitely will send out the slides, additional information, and everybody's contact information as well. So thank you all for coming, and we'll see you at the next webinar.
Thanks, team.